with no exception, including PW9 who had testified in this court, including F4 Chiseka Hassan. And my lord, in that charge and caution statement, he elaborately indicates the participation of each of his colleagues, each of the accused persons. In the case of Serunkuma Edirisa, and others versus Uganda, Court of Appeal, Criminal Appeal, Court of Appeal, Criminal Appeal number 147 of 2015. Number 147 of 2015. It was stated that a confession statement of one accused person, can be relied upon as against other accused persons. Can be relied upon against other accused persons who are co-accused persons at the trial. Can be relied upon against other accused persons who are co-accused persons at the trial. My lord, this principle is premised on Section 27 of the Evidence Act. We accordingly pray that this honorable court ably relies on the said charge and caution statement to ascertain the participation of each accused person, right from A1 to A6, and convict them accordingly. My lord, PW21 tendered in this honorable court a call data analysis report. And it was received as prosecution exhibit 42. It was received as prosecution exhibit 42. My lord, the report is detailed in as far as the phone lines that each accused person was using to communicate in respect to the execution of this offense, of the offenses indicted. It is true, as the defense has stated, that save for Mpanga Sharif, the phone numbers of the rest of the accused persons were not registered in their names. The phone numbers of the rest of the accused persons were not registered in their names. My lord, the interest of this trial were not registered in their names. Not registered in their names. Yes. My lord, the interest of this trial is not to ascertain in whose name the number was registered in. Is not to ascertain in whose name the number was registered in. However, it is to ascertain who was the holder and user of any given number, regardless of whose name it is registered in, who was the holder and user of any given number, regardless of who the registered person is. Number, regardless of who the registered person therein is. And my Lord, it was ascertained, as elaborately indicated in Prosecution Exhibit 42, that each of the captioned numbers were used or held by the respective accused persons mentioned therein. Were used or held by the respective accused persons registered therein. Got with a phone with the said numbers. Each of the accused person was arrested with bearing a phone with the said numbers. And an explanation was made to this honorable court. An explanation was made to this honorable court on the fate of the physical phones. In respect to the arson incident that befell Katwe Police Station stores. A report to that effect was tendered in court by PW 21 of the arson incident at Katwe Police Station. And my Lord, information was also given to court that the trial of the perpetrators is ongoing at the Anti-Corruption Division of the High Court in Colorado. But tendered in this honorable court in respect to the arson incident at Katwe Police Station. And also court was informed that a trial is ongoing at the Anti-Corruption Division of the High Court in Kololo in respect to the suspect. The case at the Anti-Corruption Division at the High Court in respect to the suspect who is alleged to have orchestrated the arson incident. My Lord, what is key in this call data telecom report is that Sharif, who claims to, that is A5, who claims to have been a border rider and first met Kasolo allegedly at night when they were riding him, had a phone communication with Kasolo. Had a voice call communication. A voice call communication with Kasolo. On 28th August 2019, on 28th August 2019, at 17:48, 14 hours. 17:48, 14 hours. That is at 5 p.m. during daytime on the same day of the incident. At 17:48, 14 hours during daytime. And my Lord, the same F5 had voice call communications with Kasolo on 29th of August 2019. 29th August 2019. 29th August 2019 at 19:35. That is 7:35 p.m. and on 02:28. 02:28 hours. At 02:28 hours. That is long after the commission of the respective offenses. Long after the commission of the respective offenses. So there was prior communication and communication after. And Kasolo said he did not know and he does not know any of the accused persons. And so does Mpanga say. He claims he did not know Kasolo. My Lord, Kasolo said he did not know any of the accused persons before his arrest. And in particular that he didn't know Mpanga. And Mpanga also claimed he did not know Kasolo, save for that night when he gave him a ride. Okay. My Lord, Mr. Mpanga informed this court that he went to at midnight on that fateful. Mpanga, that is A5, informed the court that on 28th, my Lord, the night, you know, it's 28th going to 29th. That night of 28th going to 29th. He claims he went to sleep at midnight at his home of August 2019. He went to sleep at his home at midnight. And informed the court that he did not have any communications with Kasolo thereafter. He did not have any communications with Kasolo thereafter. The call data records indicate that on 29th August 2019, 29th August 2019, at 02:28:20 hours, 02:28:20 hours, A5 called Kasolo. A5 called Kasolo. Not Kasolo calling A5, but A5 called Kasolo. Then at 03:36:04 hours, 03:36:04 hours, again, A5 called Kasolo. A5 called Kasolo. And my Lord, this is the time when the killing of Nagirinya at Mukono had been accomplished. And now A1 and his team had returned to Natete. My Lord, in as far as A2 is concerned, Mr. Rubega, that one, the evidence is overwhelming. The phone of Chitayimbwa was found, is seen in his phone. The SIM card line of Chitayimbwa Ronald is seen entering in his phone The money of which was in Chitaimbwa's line was withdrawn from Lubega's phone. Was withdrawn from Lubega's phone. The line of Kasolo. The line of Kasolo is also seen reflected in his phone.
Kasolo.
Yes, Kasolo's line. Reflected in the phone of Lubega. And my Lord, at some point, you know, Lubega had a phone which had ports, three SIM cards would enter. At some point, Chitaimbwa's line, Kasolo's line, and Lubega's line were all in that phone at the same time. Lubega, Chitaimbwa, Ronald, and Kasolo were in Lubega's phone at the same time. And my Lord, all this is detailed in the call data analysis report. Analysis report. My Lord, after the commission of the murder in Mukono, according to PW9, he informed the court that they drove to Natete and that the rest of the riders, that is A3 and A5, welcomed them. A3 and A5 welcomed them. And he told the court, and they shared the money together. And they shared the money together. Because as it will be seen in the call data, Lubega had withdrawn money at 5 a.m. on that day from the phone of, he had withdrawn money at 5:38 from the phone of, I think of Chitaimbwa. They shared. So A1 was, and PW9 actually said it was Kasolo who was giving everyone money. So Kasolo gave Lubega his money, he gave Kalyango his money, he gave Mpanga his money, he gave Senabulia his money. And my Lord, in this court, Kalyango and Mpanga informed the court that in that night on 29th, immediately after they carried Kalyango, that is A3, and A5, informed the court that on A5 is Mpanga. They informed the court that on that night, when they carried the Kasolos, that they paid them their transport fee there and then. They paid them their transport fee there and then. Then now we are seeing at 5 a.m. in the evidence of PW9, the same Kalyango A3 and Mpanga A5 meet up with Kasolo and the team, and they share the proceeds of crime. They share the proceeds of crime. My Lord, the movements of Kasolo from Nagirinya's home to Mukono and back to Natete were by use of Nagirinya's motor vehicle, the Spacio. Registration number UBA 570V, white in color. an exhibit slip of that
Registration number.
UBA 570V.
V.
Yes, my lord, white in color. And my lord, an exhibit slip of that motor vehicle was tendered in this court. And an explanation was made by the IO that they handed over the vehicle to the father of Nagirinya. And the father of Nagirinya testified here and said the vehicle is there and it's parked in the garage up to now. He testified in court to that effect. My lord, in the evidence of PW 16, that is Saint Pija Dennis, the owner of motorcycle registration number UEJ, motorcycle registration number UEJ 395G, UEJ 359G. He informed this honorable court that Kalyango, that is A3, went to him and borrowed his motorcycle. Which he was supposed to have returned that same night. Went to him and borrowed his motorcycle, which he was supposed to have returned that same night. But that instead, A3 returned the motorcycle in the morning. And he also went ahead and said A3 disappeared. They looked for him several days in vain.
So,
A3's conduct of disappearing. A3's conduct of disappearing is not synonymous with that of an innocent person. Basasira Elliot, that's PW20. Basasira Elliot, that's PW20. Says he co-owned a motorcycle UEO. He co-owned a motorcycle UEO 9390. UEO 9390 with his sister Naiga.
939.
O with his sister Naiga. They gave the motorcycle to A5 Mpanga to ride. A5 to ride, and he was supposed to be remitting monies to them on a weekly, every Sunday on a weekly basis. Every Sunday on a weekly basis. He informed the court that A5 last paid the weekly financial remittances on a Sunday before 28th August 2019. On a Sunday before 28th August 2019. And disappeared thereafter. That they waited for him to remit the money on a Sunday after 28th August 2019, and he was nowhere to be seen. He also informed court that A5's phone numbers, known phone numbers, were off. He was unreachable. He disappeared incommunicado. He disappeared incommunicado. And their motorcycle, that is Elliot's motorcycle, was nowhere to be seen either. My Lord, he then delved on how later he was arrested with the motorcycle. The accused persons, in particular, Basasira Elliot, when police got him with the motorcycle when they were trying to repair it. After they had got in touch with a relative of A5 and they found the motorcycle locked somewhere. A1 and A2 raised the defense of an alibi. A1 and A2 raised the defense of an alibi, which, my Lord, came at the latest stage of the trial. They never raised it when they were recording their statements at police. They never raised that alibi while at the magistrate's court during the mention of the case. As provided for under Section 75 of the Trial Indictments Act. My Lord, they never raised it. Section 75 of the Trial Indictments Act. My Lord, they never raised it at the beginning of the trial in this court or at any stage during the prosecution hearing. Or at any stage during the prosecution hearing. But my Lord, as an afterthought, and a way to escape responsibility, they raised the said alibi as they were testifying at the trial. There is no witness to whom a question, there is no prosecution witness to whom a question on alibi was put to. There is no prosecution witness to whom the question of alibi was put to. My Lord, it is the submission of the prosecution that jointly and severally the accused persons, each as is standing in the dock, actively participated in the commission of the offenses they are indicted with, actively participated in the commission of the offenses they are indicted with, pursuant to sections 19 and 20 of the Penal Code Act under the doctrine of common intention. Pursuant to section 19 and 20 of the Penal Code Act under the doctrine of common intention. My Lord, this honorable court, presided by yourself, my Lord, in the case of Uganda versus Wanyama Ivan and others, in the case of Uganda versus Wanyama Ivan and others, criminal case number 351 of 2020, number 351 of 2020, 1 of 2020. My Lord, you, Justice Muata, stated that court presided over by Justice Muata, most obliged, stated that each of the accused persons are liable both individually and collectively under the doctrine of common intention. Collectively under the doctrine of common intention. You further said, an unlawful common intention. An unlawful common intention does not imply a pre-arranged plan. Does not imply a pre-arranged plan. You said common intention, you further said, the court further stated that common intention may be inferred from the presence of the accused persons, their actions, and the omission of any of them to disassociate him, the presence of the accused persons, their actions, and the omission of any of them to disassociate himself from the assault. My Lord, the prosecution contends that firstly, the actions of each of the accused persons, for instance, the actions of F4 Chiseka to mobilize, to coordinate, mobilize, facilitate a successful and good wrecking process. His actions of providing a red jacket to Kasolo, to conceal a toy pistol, among others,
the action is of the person.
most obliged. And my Lord, none the said offenses. And my Lord, in respect to F4, for instance, his actions, which I elaborated before, constitute the actions that are implied within this provision of the law. And my Lord, I need to also earmark that none of the accused persons disassociated themselves from this criminality. None of them reported to police at the earliest opportune time. But what is clear is every one of them scattered into hiding. Every one of them scattered into, and it took a joint security team and high-tech technology to arrest all of them.
My Lord.
Only. My Lord, I have to make... My Lord, because I'm responding to submissions of 6 accused persons. For them, they were only making submissions in respect to their own particular clients.
Not beyond the project.
Most obliged, my Lord. I can time myself.
So you say they don't report
at the earliest opportune time. But instead, each of them scattered into hiding and were only arrested through a collaboration of a joint security team. Collaboration of a joint security team using high-tech technology. My Lord, in the decision I'd cited, that is Uganda, most obliged.
Using, you said sophisticated.
Sophisticated technology, yes, my Lord. In the said case of Wanyama Ivan, this Honorable Court also added something which is vital. It said, it is immaterial whether the original common intention was lawful, as long as the unlawful purpose develops in the course of the events. It is immaterial whether the original intention was lawful, as long as the unlawful purpose develops in the course of the events. So it's inconsequential whether A3 and A5 think they were mere border men. But resultantly, offenses were committed. Resultantly, offenses were committed. My Lord, I'd indicated that it's immaterial whether A3 and A4 claim they were mere border riders, which the evidence has not indicated the same. And F4 were mere border riders, which the evidence does not indicate. Or whether F4, for him, his work was only to mobilize and he did nothing more. It's inconsequential, as long as an unlawful purpose develops in the course. And my Lord, it's because of that unlawful purpose that this court is sitting here today. This Honorable Court be pleased to effectuate justice by convicting each of the accused persons and disregard the lies that they have told this court. Lastly, and this is the contention of the prosecution, that the statements and allegations that have been raised by each of the accused persons are lies, and demonstrate that each of the accused person is, each of them is an acclimatized liar, a certified criminal, and bear rancorous personalities and do not deserve to be in this society. I so pray, my Lord. For example, Kasolo said PW9 was a police officer and there is no evidence to buttress that. I'm well aware that he does not have the obligation to prove that. But my Lord, there is no evidence to that effect. To the contrary, prosecution, PW9 was a police officer. My Lord, A1 also indicated that PW9 is the one who tortured him at Katwe police station. Thus, the allegations of torture which he is raising. A1 and A5, A2 both raised alibis which were lies. A3, A5, and A6 all lied about not participating in the commission of the offense. My Lord, the law is clear on lies. In Uganda versus Bogere, Banuli, criminal case number 437 of 2010, it states that that where lies approved on the part of the accused person, where lies approved on the part of the accused person, such lies make the inference of guilt even stronger, and may amount to corroboration. My Lord, I pray that this honorable court finds the said decision helpful. And my Lord, and adopts other decisions that we have cited in our submissions on lies. There's a Supreme Court decision, there's a Court of Appeal decision, there are many there. My Lord, Mr. Kasolo has indicated in this honorable court that the prosecution did not produce the eyewitness, that is bane. The same submission was made by counsel for A2. My Lord, we find that submission not necessary. The evidence that is available is sufficient. And the Evidence Act is clear. There is no amount or number of witnesses that is required to prove a case. Mr. Kasolo also contended that with the Evidence Act is clear, there is no amount or number of witnesses that is required to prove a case. A1 also contended that he should be acquitted because a toy pistol was not produced, a toy gun was not produced in this court. My Lord, in the case of Kamiuka Ivan versus Uganda, Court of Appeal, Criminal Appeal number 56 of 2018. Criminal Appeal number 56 of 2018. The court stated 56 of 2018. The court stated that recovery of a weapon used in committing the offense, is, my Lord, they use the Latin word here. Maybe it means is not a condition precedent. They use is non a sine qua non. Non, N-O-N, then sign is S-I-N-E, qua is Q-O-U, then N-O-N, meaning condition precedent. It says is not a condition precedent to convict the accused person. In other words, it's inconsequential whether that pistol was recovered or not. Kasolo knows where he threw it anyway. My Lord, Kasolo also contends that DNA was not got from the steering, which is claimed to have touched while driving. My Lord, PW18, the girl expert on N.
He said it's from the car. Did you say the steering?
Yes, he mentioned the steering, or even the car entirely. But PW18, that's on N, informed the court that the reason why some DNA may not be obtained is because DNA degenerates over time. It says DNA degenerates over time. And as a result of that degeneration, Kasolo's DNA was not found. Yet the photo that was tendered in court indicates that it is Kinawataka. My Lord, what is critical is that Senabulia informed court that they passed through Kabusu. About Kinawataka. Yes. My Lord, what is critical is that Senabulia informed court that from Runguja they passed through Kabusu. They passed through Kabusu, informed the court that they passed through Kabusu via Kinawataka to Mukono. And the same route where the to Mukono via Kinawataka to Mukono. And that's the same route under which they said ANPR camera captured the photo of Kasolo driving. And Senabulia informed court that was Kasolo. And that evidence was never controverted. Never. Informed court that the person in that photo.
Did you show him the photo?
Yes, my Lord. It was showed on the screen here. And that evidence was never controverted by Kasolo. Kasolo prays to this honorable court to be acquitted. Kasolo prays to this honorable court to be acquitted because he was held for more than 48 hours in police custody. My Lord, in the case of Behangana, Damano, Behangana, Domano, and another versus Attorney General. Behangana, Domano, and another versus Attorney General. Constitutional Petition number 53 of 2010. Constitutional Petition number 53 of 2010. The Constitutional Court had this to say. The Constitutional Court had this to say. It stated that there is nothing unconstitutional. There is nothing unconstitutional in preferring charges against a person. In preferring charges against a person that has been held in custody longer than 48 hours. That has been held in custody longer than 48 hours. My Lord, in the case of Serunkuma Edirisa, which I had cited earlier, it actually states that even evidence obtained in the period when the accused has been held more than 48 hours is admissible in court. Evidence obtained in the period when the accused is held more than 48 hours is admissible in court. Obtained at the time, during the time when the accused is held for more than 48 hours is admissible in court. My Lord, I've already responded in passing to the submissions of Counsel Serwambala. Counsel Serwanga stated that the accused persons were not informed that what they would say at the scene reconstruction would be used in court. And as such, he prays that the evidence on the scene reconstruction be disregarded. My Lord, lack of caution in itself does not disqualify the evidence on trial. Lack of does not nullify the evidence in a trial. I pray court gets guidance in the case of Baliyendera Simeo, Baliyendera Simeo versus Uganda, Criminal Appeal number 109 of 2013, 109 of 2019, which is to the effect that the evidence should be looked at as a whole. The evidence should be looked at as a whole, and when evidence points to the guilt of the accused person, and when the evidence points to the guilt of the accused person, then that other contested evidence should be adopted. Then that other contested evidence should be adopted. And my Lord, that includes evidence where the accused person was not cautioned, or even hearsay evidence. Evidence such as where the accused person has not been cautioned, or even hearsay evidence. My Lord, in light of the above submissions, and taking into considerations the written submissions that was earlier filed by the prosecutions, my Lord, the law on accomplice evidence is clear. In the Evidence Act, it is to the effect that there is no mandatory need for corroboration for the accused person to be convicted.
What is that system?
My Lord, I can get it in a short while.
Okay, you continue. We'll get that.
Most obliged, my Lord. There is no mandatory requirement of corroboration for the accused person to be convicted on accomplice evidence. And my Lord, in the case of on accomplice evidence, in the case of Katoka Jubi, which I had earlier cited, yes, my Lord. Actually, in that same case, it was buttressed still. However, I need to say that there is a wealth of corroborative evidence in the instant case. Most obliged. There is a wealth, and that includes the data analysis report, the technical report that was tendered by Frank Nyakairu, evidence to implicate all the accused persons.
Implicate all the accused, including
that includes the data analysis report that was tendered by PW21,
the data analysis report too.
the technical report that was tendered by Frank Nyakairu, the police
Hold on, the technical.
reports that was tendered by Nyakairu,
That's PW.
PW, I think 8. Then it includes the postmortem reports. The postmortem reports that were tendered, that's prosecution exhibit 1 and 2.
The post-mortem reports.
Prosecution exhibit 1 and 2. Then the police form 27, the search certificates, the scene reconstruction footage, the CCTV video, the panga. My lord, the exhibits are over 30 exhibits. The list is endless. All corroborate the fact that Kasolo Kopriam, Rubega Johnson, Kalyango Nasif, Chiseka Hassan, Mpanga Sharif, Katerega Sadat, including the one who pleaded guilty, Senabulia, all are culpable, jointly and severally, of the offenses that they are indicted with. My lord, I am...
muntu yazza musango agamba nti kino kukirangulula kooti ebiwulira musango misiri ku peegi namba 31 peegi zakoze bwatyo ate kibolera ku namba 6.
No, I'll respond orally. After this, when you people submit, I'll respond. Okay. Yeah. Because, you know...
But already filed our submission.
Yes, I could respond to those ones orally. I don't intend to put written.
Have you brought the other man for prosecution?
I learned today that he had been summoned. That you people had issued summons on him. But he's not, no.